let us begin the public hearing. So with that, good evening, everyone, and welcome to the Milton Board of Appeal. This is the continued hearing of the application of the provisions of Chapter 40B relative to 936 Brush Hill Road. My name is Frank O'Brien. I'll be acting as chairman for this hearing. Joining me are board members Jeff Mullen and Nicholas Gray. This evening, just to set the stage for what folks are going to be watching this evening is this. The board has completed its extensive public hearing relative to the evidence portion of this particular application. The last evidence hearing was on September 29th, 2022. The evidence portion of the hearing was closed pending the submission of an additional peer review document from the town's engineering traffic peer reviewer. And that was indeed submitted by Mr. Sean Reardon via a letter dated October 3, 2022. And that letter was submitted pursuant to an agreement amongst the parties. So at this stage, the public record for the hearing, insofar as the evidence portion of it is complete. And for those folks who may be interested, all of those materials are available in the 40B portion of the Town of Milton website. So this evening, what we will be beginning is the deliberation portion of the hearing. And these deliberations are public under the provisions of the open meeting law. And so the board will, over the course of the next several meetings, begin its review of various draft documents, draft decision, draft exhibits, etc. I would emphasize to members of the public that these are drafts. At some point in time, a formal decision, a formal vote by the board will be taken when the board is satisfied that it has reviewed the drafts that have been prepared by its consultant and others. So all of the documents, all of the discussions are draft only, and no one should read into it whether there has been a decision made one way or the other. There is no official decision made on the part of the board until an actual vote is taken, and that will be somewhere on down the road in this process. Also, during the course of this part of the public hearing, there will be no direct input by members of the public unless specifically requested by the board. Typically, the non-board members who participate in this process are consultants or others who have been invited to assist the board. On occasion, the board may reach out to a particular peer reviewer, the applicant, or some other party for a specific question. But at this point in time, no additional testimony will be heard by the board. As I have mentioned, the public record is closed. So what you'll be seeing tonight are members of the board reviewing various documents, discussing various language changes, what goes in, what goes out of the decision. And that is the process. So both Mr. Gray and Mr. Mullen and I have been involved in this many times in other cases before the board, and we have also been involved in this in previous 40B decisions. I would also mention that under the provisions of 40B and its accompanying regulations, the board has 40 days from the close of the public hearing on which to render a decision. And given that the record of the public hearing by my account closed on September 29th, I believe the deadline for this under the 40-day rule, if I could call it that, is November 17th. Does anyone disagree with my ability to do arithmetic? Does not appear so. So, at this point, Mr. Sawinski, it doesn't appear that Ms. Barrett or Ms. Rich, it doesn't appear that Ms. Barrett has been able to join us yet. Is that correct?
That is correct. I don't see her.
Okay. Tim, have you spoken with Ms. Barrett?
Judy is on the road coming down from Maine right now. She said that she intended to call in. So I think we can expect her. Hopefully sooner rather than later, but her intent was to call in to the hearing tonight.
Okay. Gentlemen, a draft of an initial draft of a proposed decision was provided to members of the board before the meeting. The draft that I have before me is approximately 30 pages long. It does not currently include the draft conditions. I understand that Ms. Barrett did not have a Word version of that. I don't know if she has been subsequently provided with one. I do know that a PDF version of it, and there I understand there may be some conversion related issues.
You talk about the waivers?
Yeah.
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 Okay.
So my initial plan for this evening would be to review the initial draft of the decision. There are a number of holes that I've already identified which would need to be filled, which I think would need some discussion by members of the board. Is that initial plan meet with your expectations?
Yeah, that's fine. I think we should take a look at these waivers too, if we can.
Yeah.
That sounds great.
Which would you prefer to start with? Would you prefer to start with the decision, or would you prefer to start with the waivers? I could go either way.
Judy's going to join. I think it would be better to do the waivers with Judy there because as I read her email, she wanted to know about whether there were issues with the waivers. That's what I
Right.
took from that email.
Right.
And my only issue with the decision, Frank, is, we just got it.
Yeah.
I haven't read it,
Okay.
you know.
Okay.
So, I mean, I've read it, but I haven't spent enough
Yeah,
time with it.
I
to
know.
really put input.
I spent Sunday I had the advantage of spending Sunday with it.
They just come in last night?
Yeah, but I went ahead and started to do it on my own too. So
Okay.
I
Okay.
I had a day today, so I was a little concerned that I wasn't going to have enough time to review stuff before I came in. So
Okay. I mean, looking at it, it looks and feels like the other. Let me say this. Do you want to have a discussion or?
I'd like, you know what, I'd like to have, I think that a lot of this is very, very similar to the Amor Road, the outline for the Amor Road decision and the outline for earlier decisions that the board has produced. I mean, as you guys know, as the board knows, there's a certain format for these things, and we've learned the hard way that we kind of need to follow that particular format. for no less reason than economy for our town, for our consultants. And also by doing that, you make sure that you haven't forgotten anything. As I said, a lot of this is at least initially informed based on the Amore Road decision.
Yeah.
But Amore Road and Brush Hill Road are two different, while a lot of the stuff is similar, there are specific differences that have to be put in place relative to this. So,
So you asked how you would want to proceed. I mean, I think it would help Judy to hear the conversation about the waivers. So maybe you want to start with the draft of the decision
yeah,
first. But
okay. And
it
let's
might be
start-
helpful just to make some preliminary comments about where this is headed.
Yeah. Would you care to start?
I mean, I was just going to share with I was going to share with the board that I read the materials. I read Mr. Reardon's letter that I was concerned about the last meeting. And I read this permit application, the draft of the permit application once, but I need to read it in more detail to give you quality comments. My sense is, subject to this deliberation, that this is an application that can be approved with conditions. And I think that the local concerns can be addressed through the conditions that the board decides upon. In terms of this draft, a lot of it is generic, as you say. One thing I think is lacking is an expression, and Judy acknowledges it in the draft. I think we need to work a little bit more on the conditions that Mr. Galvin and his team had articulated, just to flesh that out. That was one takeaway from my read. But on balance, and I wanted to, I think we should have a more detailed conversation about the waivers. But on balance, I think that's where this that's my sense of where this is headed.
Okay. Thank you. Mr. Gray, would you like to make some?
Yeah, I would tend to agree with that. It's the room for the board to outright deny an application, given that the town isn't not yet meeting one of the two prongs for a safe harbor, is pretty limited. And I think that that Mr. Mullen is correct, that with the right set of conditions, that it's likely that this project could be approved. I mean, it was subject, of course, to our discussion about it, and our deliberations. I may change my mind after listening to you guys talk, but that's kind of where I think, where I'm headed at the moment. Again, subject to what we just, our further discussions as we deliberate on this.
Thank you. Well, I agree with my fellow board members. I do think that this application, with the drafting of appropriate conditions, is at a place where it could be approved. If you look at the overall standard for 40B, which essentially, to paraphrase, if you will, that in order for it to be denied, local concerns would have to outweigh the regional need for affordable housing. Given the status of that particular situation here in the town of Milton, I think it's a judgment call, and in my view, the local concerns can be mitigated with appropriate conditions, and as a result would not outweigh the regional need for the type of housing that 40B is designed to produce. Now, that presupposes that we're able to produce conditions that are acceptable. There are a number of issues, but I think as a starting point, it sounds to me like the board is in general agreement. So, All right. So with those opening statements, perhaps is it the board's pleasure to begin to take a preliminary look at the initial draft of the decision, understanding that further and more intensive review and deliberation by the board and study by the members of the board will take place, and this is a preliminary review, preliminary comments. I would almost equate it to initial issue spotting, if you will. Some ways I feel like I'm back in law school briefing a case. So, sound good?
Yep.
All right.
Yeah.
All right. So, the initial page, which lists paragraphs 1, 2, 3 in the beginning of 4, it is, we have here some, actually, the first several paragraphs going on to the second page. We have the initial review, the procedural history of the case. I've taken a look at it initially. I do think it needs to be reviewed with a weather eye, as there are a lot of details and numbers here that we just need to make sure that they are all correct from an editing point of view. Some of these, particularly some of the dates in paragraph 3, will change as the board schedule.
I'm sorry, Frank, before you
Right.
talk about paragraph 3, could
Sure.
on paragraph 2, just, I mean, I'm assuming people listening to this, they don't have the draft, so let me just say what the paragraph says. It talks
Good point.
about,
Thank you. I'm sorry about that.
it talks about it talks about a letter to the board acknowledging that the board was entitled to stay the opening of the public hearing, and it references other applications that were pending. It doesn't add anything else. I mean, we didn't stay this, right? Or did we stay this? And I'm wondering what's the purpose of that paragraph? I actually don't remember if we stayed this or if this was postponed on account of the pending other applications. If that's the case, then I think that makes sense. But otherwise, I don't know that it adds anything. And I'm wondering what's going on there. Maybe you just put a marker down. It just struck me as, okay, I mean, that might be a good fact, but it doesn't add to the decision as far as I can tell, unless we acted on it.
You raise it. You know what? You raise a good point. I think we should mark that for further review. I do.
Could we, I don't have it in front of me, but could we put it up on the screen? Is that possible? Because if I'm remembering correctly, this was, these applications for 16 Amore, 936 Brush Hill, and 728 Randolph Ave came in while the board was still reviewing Blue Hill Ave, Blue Hills Parkway, and East Milton, which under the regulations, we are allowed to stay the opening of hearings on additional applications if have active hearings for a certain number of units, which we did.
Yeah,
So
that's
I think-
exactly what that paragraph's about, Tim, but what I'm not sure on, it doesn't say that we did stay it. That's all I'm saying. I just,
I
but
could,
that's the purpose. Go ahead. I'm sorry.
no, go ahead, Jeff, I'm sorry.
No, I'm good. I'm good.
No, I was gonna say I'm not technically a wizard with Zoom, but I could try to share my screen if I opened up that Word document, which I have open at the moment. Would that work? Is that?
Yeah, you know what? I just tried to do it, and I don't have permission to do it. So, Crystal, can you give me permission to share a screen?
Yeah, everyone should be able to. I have it on share screen. I'm
I'm
not sure
getting a message,
why.
most disabled participants screen sharing.
All right, let me double check. Yeah, I have it on. I'm not sure why it's doing that. Hold on.
Okay, I can do it now.
Hold on a second. Is it still working?
Yeah, I can do it now.
Okay.
Look at that. There we are.
All right, can you guys see my screen?
Yes.
Fabulous. So,
Oh, I see what Jeff is saying there, that it says that the board received a letter from the applicant acknowledging, et cetera, et cetera, et cetera, but it doesn't actually say, and then the board stayed the hearing. So I was a little confused about that, but reading that, I get it precisely. So, I mean, if there was, the way that stay functioned was, it was sort of a series of continuations. So we should probably go back and just get the dates of those hearings. There were maybe 2 or 3 where it was just open for the purpose of continuing, the agreement that we had with the applicant was sort of to do, it was something like monthly check-ins, to see when the other hearings would have closed. So, there's probably a series of dates we should get in there.
I can go back and look for the dates tomorrow. It's for you want them for every single hearing we've had, right?
Yeah, and the first handful would be non-substantive hearings. It was just a quick minute open and close.
Okay,
But they would have been posted and whatever.
right.
So
Okay, I'll double check it tomorrow.
okay, you know what, Jeff, thank you for pointing that out. I dived into it a little too quickly because looking at this, looking at past decisions, there were, one of the things that is missing here, at least I did not see it in the screen that I'm sharing, is the verbiage that notes that there were COVID-related restrictions, COVID-related delays, and emergency orders, which told the public hearing and things like that. I know that particular language, for example, was in the Amor Road decision, and since the Amor Road case was being considered around the same time that this one was progressing, I wonder if that COVID-related language, remote meeting, stuff like that, would also need to be included here in the procedural history. So,
No objection to that. I mean, whatever's appropriate.
yeah. Paragraph 3, which deals with the opening of the public hearing and the dates that it was continued on, is consistent with some language that I think I provided the language to Ms. Barrett relative to paragraph 3. And I went through the record and put those dates in. If Ms. Rich or Mr. Sawinski just would care to double check me on those dates. And of course, there are some dates that need to be added relative to the dates for the board's consideration of the decision, that would be helpful. Also, what would be helpful, Tim, is in paragraph 4, I grabbed the assessor's map information from one of the submissions, I believe from the applicant. And I just want to double check that the identification on the Milton assessor's map is correct. I did go to the Milton, the assessor's website and double check that, but I've learned that you got to make sure you got to triple check stuff.
I will triple check that first thing tomorrow.
I know it's a minor detail, but the verbiage in paragraph 5, which is a brief discussion of the physical location of the site, that's consistent with how the site is described in some of the materials that had been provided by the applicant, at least in their initial filing. I used the term near Curry College as opposed to adjacent or what have you. I hope that adjective is acceptable to the board. If not, that's fine.
Well, it certainly is near, so that works.
I don't have any additional comments relative to 6, 7, and 8. The 6, 7, 8, and 9 for the most part, because it lists the players in this little drama.
Yeah, the only thing about 9 is I know that Mr. Galvin represented some of the abutters, but I don't believe he represented all of the abutters. That was one point. And then thematically, I thought we heard consistently from the neighbor across the street. The neighbor whose property is directly to the left, if you're looking at the property, and then the folks on Cushing Road, who were consistently represented and expressed concerns about traffic. So I just think I think this paragraph can be significantly enhanced with some texture on those that I think could inform the final result.
You know what, I would agree. And then there's a later paragraph that deals with certain notices that need to be sent out when various activities go on. And it wasn't clear to me, for example, if Attorney Galvin represented the Cushing Road Neighborhood Association, or if it was those types of notice should be sent to the president of the Cushing Road Neighborhood Association, stuff like that. So I think that bears some that bears some looking up. And of course, also in that area, the concerns of the abutters obviously need to be summarized. And in my view, the concerns, very briefly, that had been expressed by Mr. Galvin and the abutters and other members of the public concerned the density of the development, the capacity of the site, fire department / public safety access to the site in the event of an emergency. The number, size, and materials that would be used in the construction of several of the required retaining walls, parking, traffic issues, and in particular, traffic issues involving the driveway sightline issues. So those are the ones that I identified initially as issues emanating, and which would require further exploration, further drafting, and maybe there are others that I haven't articulated, but that was my quick review of my notes relative to that. One of the things that I did not list in that is drainage and drainage screening, essentially landscape issues. So I do think that paragraph 9 needs to be beefed up relative to listing those issues as well. Am I missing anything?
I was gonna say exterior lighting and light of headlights proceeding out of the garage, but that might be included in your in the landscaping discussion. But certainly that was, you know, the external lights on the property was a concern as well.
I think it got enough attention. It probably merits a mention
I think so.
on the.
I mean, there
on
and
the
there
laundry list.
in response, there was a lighting plan, analysis and stuff. So yeah, I absolutely. I think we should discuss it. They need to consider conditions about it as well.
Okay. All right, I would invite the members of the board to these are the issues that I thought.
Okay.
Just to show folks the list. As you can see, and of course, my skills as a typist are on display for all to criticize here. So,
No judgment.
so just a quick list here, and I will add lighting. So this will be shared as well. So I want to make sure that we summarize in a fair way, in a laundry list kind of way, at the very least, the concerns of the abutters and other members of the public relative to this. Here.
Mr. O'Brien, are we included? Did you already mention in your list? I've tried to make the notes. Anything about the discharge of overflow of water?
I did not. I did say drainage issues, but
Yeah.
I did not.
Just going back over my notes from their presentation to see if I can pick anything up. I mean, there were test pits, additional test pits that people wanted dug, and they were dug. Yeah.
The latest letter from Tetra Tech is very helpful in that regard, because a lot of the issues were engineering issues, if you will. And that letter was helpful. At least I thought it was helpful in summarizing a lot of the stuff. between that and the notes, but again, my notes aren't perfect, so.
Yeah.
Also, of course, reviewing the materials that Mr. Galvin also presented as well in terms of. So that needs to be worked on. Any objection to moving on to paragraph 10?
No,
Nope.
Okay.
I mean, to your
Uh,
earlier point, this is the first version of this, so I know people are looking at this for the first time, and I mean, with respect to your edits, Frank, we are too, so.
Yeah, this has to be considered a rough draft.
Yeah.
There's no way I'm submitting this to the professor for a grade. So,
No,
but it's part of the process, and it's part of the process that people will see because of the open meeting law. This is how the sausage gets made, I guess.
I was just thinking that same phrase. Yep.
So I'm going to try to move on from cliche land and try not to delve into that anymore this evening. But moving on to paragraph 10. This one was this is pretty basic. It just these are the dates as far as I could ascertain relative to the I believe these are the dates that the additional. Hold on a second. Yeah, these are the dates where the applicant submitted revised plans, and as you can see, the initial plans, first revision, then second and final revision on these particular dates, and these dates are both from my notes and from the dates of the particular presentations. The next paragraph is based upon the I believe that this was this is based on the initial peer review, the letter that was submitted to the board on June 27th. If I recall, that was the second or third communication from our architectural peer review consultant, Cliff Bomer. And these are and the initial review of the comments that were contained in that submission. This as well is one of those ones that I question whether we have captured the full range of comments that were provided to the board. I also think that some of this language may need to be reviewed and considered. And so paragraph 11 in particular is one of those areas that I think the board, I know in your review and reading of it, I think it would be one of those paragraphs to take a look at, and are we saying the right things in the right way on that in terms of the comments that were received from the architectural peer review consultant, and have we captured all of them? Similarly, in paragraph 12, though it is a little bit shorter, these are the comments of the board civil engineer and traffic consultant. And this verbiage is actually drawn directly from the final comment letter. And basically, almost everything has been addressed, and that those conditions that have not, those issues that have not been addressed specifically in the letter, there are a number of suggestions that Mr. Reardon makes for specific conditions to be included as part of this decision. And I think that at the appropriate time, those would be included and incorporated at the appropriate place in this decision. So I think that Mr. Reardon's last submitted letter bears careful review. Again, it's one of those ones I want to make sure that we've got everything.
Not that I want to necessarily get into wordsmithing every line in this thing, but 12A, the first two words kind of jump off the page to me a little bit. Is it almost most of the original? Can it be either most or almost all, but not almost most?
Ha-
I don't know what almost most means. So really, that's
happy to make that change.
there's a giant change.
Happy to make that change. 13 is self-explanatory, obviously. I think that generally speaking, the next session, the governing law and the paragraphs in Roman numeral 2, governing law, paragraphs 14, 15, 16, and 17, which are now on the screen. I don't want to denigrate them. They're needed. Every decision needs to list out what the governing law is, but essentially it's boilerplate.
Can someone just verify that that's what's been in the board's decisions consistently?
I can tell you that this was drawn specifically from the Amor Road decision, so I think we'll go back and double check the other decisions as well.
I mean, in terms of the boilerplate, are we not really up to item 21?
I believe so. I think you are correct that at the beginning of Roman numeral 3, jurisdictional findings, the first several paragraphs, 18, 19, 20 are boilerplate as well. As is, would you say that most of 21 is as well?
Yeah, I just was thinking about the dates, that's all.
Yeah. Let me double check 21, the date on 21. Yeah, that's the date of the PEL. You know, as I said, it's easy to make mistakes on dates and numbers. So a
Yeah.
lot of these dates and numbers and some and the citations, we'll have to double check to make sure that they're correct. Because it's just way too easy to screw up a citation or a date.
I'm trying to do it on the fly, comparing the boilerplate to an old decision, but it's probably better to do that more thoroughly off camera, where we, can really compare things as opposed to sitting here and trying to do it on the fly. But it's 17, the prior section, the governing law section looks, as far as I can tell, is nearly identical. Without actually, doing a side-by-side comparison. It's to what was in the previous decision that we worked on.
I know that this language was drawn en masse from prior decisions. With some additional language, for example, in paragraph 18, subparagraph D, it notes that a comprehensive permit was issued for the units at Amor Road, but there have been no appeal has been filed on that. I believe the Amor Road decision was just that was just last week. So
Yeah, there's time yet.
Yeah, we are in the appeal period. So
If we're gonna cite where Canton Ave was appealed to the HAC, we should cite where the rentals were appealed. It says they've been appealed by the abutters, but we ought to know to where they were appealed. I think we're in court on those.
okay.
It's based on the mail that I get. We're in court on those.
Is that for Canton Ave?
I don't know. There was 3 appeals, right? Blue Hill Avenue was
Yes.
appealed.
Yeah, 640 Canton Ave was appealed. They are in court.
Right. It was just say, to the land court or the Superior Court. I just don't remember exactly where they were appealed. I'm just saying, if we're gonna say one was appealed to the housing appeal, we just, to be complete, we ought to.
Yeah,
You just say all of them.
Well,
appealed
East
too.
Milton was appealed to the land court.
Yeah, that's what I thought.
I mean, that's where it is now. It didn't go there initially, but it's been removed to the land court.
Okay.
Whatever. I mean, just.
Yeah.
Yeah, it's a detail that matters, and as everybody knows, the details in these decisions matter. So we can get that. If I recall correctly, wasn't Blue Hill Ave Superior Court?
I'll speak to our 40B council tomorrow about this, because I think they were all appealed to Superior Court, and I think we are trying to get all of them into land court, and they may be in different stages. So I'll talk to our council tomorrow and just make sure we have the fully up to date version of that, and I'll get that to you, Frank.
Okay, let's do a summary status. Let's not drive ourselves crazy by saying currently in Superior Court pending removal to land court or something like that. Just what's the current status? Let's not drive ourselves nuts there though. Okay. Tim, is the statement in paragraph 19, is that essentially correct?
Just give me half a second. You said paragraph 19?
Yeah.
Right.
That is not inaccurate. So, sure.
Not inaccurate, but not correct.
No, that is a factual statement, undeniably true.
That's all right. That's fine. I get accused of saying I don't disagree with you a lot. So
Sounds like Tim's been hanging around with a bunch of lawyers too much.
I know I feel very bad for Tim. That was a very lawyerly answer he gave. Oh God.
All right. All right. 20 is essentially boilerplate, I believe. 21 is, it's almost a form paragraph.
Just checking the date.
Yeah. So anyway, we'll just need to double check those dates, double check the citations, that sort of thing. All right, factual findings, Roman numeral 4. Paragraph 22, the first sentence essentially replicates the location language found earlier in the decision. The second paragraph there, I'm sorry, the second sentence in that paragraph is a sentence that has been present in prior decisions. I just wonder why and what it adds. I mean, I just saying that in general, I don't have a particular objection to it. I just don't know why it's there.
Yeah. I mean, it's not false, but it's also not
Comprehensive.
comprehensive. Thank you. Oh, I mean, you know, further to our initial discussion and Mr. Mullins' amazing status as the town's greatest bicyclist. All of those amenities, I know from personal experience, are accessible by other means as well, you know. But if the real question is, do we need a sentence in that, as you correctly point out, do we need a sentence in that section about that topic at all?
Well, you know, I assume that it was there because there are regulations out there that encourage the applicant to comply with the Commonwealth's smart growth regulations, right? Which are encouraging dense development in areas that are more accessible than accessible by auto. I assume that was what that sentence was for.
Okay.
I was actually going to question if whether it's accurate, since it's, I mean, it is walkable to the Blue Hills, but
You could walk, I mean, you know, it's not. You could walk to Fowl Meadow from there without much trouble. I know it's a narrow street. It's doable.
yeah, you could say primarily accessible primarily by car. If I were if you know, I mean, I think it could be an important fact in another proceeding potentially. Just so,
Okay.
I think it would be more accurate if it said are accessible primarily by car.
Well,
Something.
so there were two things that were going through my mind when I was questioning this. One is a recent Boston Globe article, because I've been sensitized to the plethora of bicycle-related transportation in the regional area. The second is that, on a more serious note, there were a number of folks who participated in the hearing who strongly questioned the accessibility of this particular site by bicycles, pedestrians, etc.
I think their objections were mainly pedestrian.
Yeah.
Yeah.
So,
yeah.
You know, I mean, it does. Is it needed, and does it go far enough? Is it needed? If it is needed, does it go far enough? Is my question.
Well, I think we need to decide. I'm sorry, Jeffrey. I think that we need to decide how accessible the site is we need to make a finding of fact about it. If we find it's accessible by other means, we should probably specify what means we actually find it to be accessible by.
I don't think we have to decide that this evening, but I want to raise that because I
Yeah.
do think it is something that I think the members of the board may want to wrestle with. Again, because it was such a, dare I say, bone of contention during the course of several of the public hearings with, again, several members of the public speaking quite strongly on that issue. So.
What you could do, I mean, you might have another sentence. So the other issue that people objected to was its proximity to the commuter rail station, right? With their
Yes.
suggestion that you can actually walk there. And while it's not far, nobody walks there, and everybody knows nobody walks there.
That is correct.
Probably
That's
because you have to
absolutely
walk up the mountain to get down there, right? So, you know, you could supplement that by saying something like that. You know, you could say the board finds that the commuter rail station is not accessible. I don't know that way.
Foot. You can
It's
access
something
it by bike, but you know, it's not easily accessible by foot. I'm talking Reedville.
Yeah.
right? The Reedville station itself, as opposed to Fairmont.
Either one.
Yeah, no, either one, it would be a haul by foot. I mean, a hardy person could do it, but you're right. No one is going to, I don't think, in the morning, try to do that. You could bike it, but then you need a place to lock it up. That's the issue for me.
And I think there was also a fair amount of testimony that it's not safely walkable for a pedestrian.
I agree with that.
Yeah, I mean, that was opinion by the abutters. And yeah, I think we can weigh that. That certainly was their opinion.
Okay. Anyway, what I think I'm hearing is that there is a consensus on the part of the board that additional attention needs to be paid to the language in this particular paragraph. The next paragraph, paragraph 23, again, in the.
I'm sorry. The other thing that 22 might say is that the site is located on a scenic road.
Yeah.
Good point.
And are trucks still banned on that road? I seem to recall that they are. I don't know if we want to get into that, but
Well, at some point in time, with the trucking plan and stuff like that, that's going to have to be an issue. And
Yeah.
we should discuss that at the appropriate point in the decision. Again, there were significant concerns raised, especially by folks who talked on behalf of the Cushing Road Neighborhood Association.
Yep.
Concerning that.
Yep.
So, okay to move to 23 and 24? I mean, 23 and 24, again, are decisional in nature, but they're also, to my mind, boilerplate decisional, if you will. And they are consistent with the language in prior decisions issued, but not only consistent, but identical to language contained in prior decisions by the board. So, is there any need on the part of the board to deviate the language in these two sections?
I would say no.
So,
no.
okay. Okay. So paragraph 5 is the draft decision in and of itself. And again, boilerplate language with essentially the only deviation is just the insertion of the correct number of units. And of course, whether the the comprehensive permit is granted or not. So. All right. Any objection to moving to Roman numeral 6?
No,
No,
So the general conditions. Again, a lot of these general conditions are general. I don't know how better to describe them. And they are typically made applicable to most or every project, at least the ones I'm familiar with. Basically, A1 is thou shalt comply with the provisions of 40B and the appropriate sections. In A2, basically the acceptance may be provided in the conditions or in the final plans referenced below. Projects in conformance with the plans and drawings listed in Exhibit A, which later on, when we go down to Exhibit A, it's not there now, but in Exhibit A, we will need to have a listing of the final plans. And Mr. Mullen, I recall a hearing that you and I sat on where we got a little twisted around the axle in terms of the terminology associated with plans, because we had plans, final revised comprehensive plans. I'm planning not to be as wrapped around this particular axle, so I just want to flag for folks that right now, I'm trying to refer to this in this thing as final plans. And I want the plans in Exhibit A to be the final plans or whatever. I want us to be consistent with the descriptions throughout so that we don't confuse the applicant, town officials, or members of the public as to what plan is which. Maybe Mr. Mullen, you could plan to take the lead in being the determiner of the plan verbiage.
okay, that's fine.
You have demonstrated expertise in that area.
I remember that. Yeah, okay. That's fine. This seems to be much improved from where we started, though. I will say that. So we've learned a lot in the last couple, 3 years. So.
Yes, we have. It's still more lessons to be learned, I fear. Because, already I see some of the language in A2. It's like final plans, approved plans. It's like, okay, what's what and who's who. So, A3 is, again, pretty boilerplate. A4 is also boilerplate, but it's the only changes are those changes which are consistent with the number of rental units and the type of rental units that are included in here. The 20 rental units in this particular the count 818243 bedroom units is taken from the tabular summary of the project, which was included in the materials submitted to the board during the hearing. So 20 units total divided up in that way. This is obviously one of those ones we'll just have to double check. By the way, while I'm thinking of it, one of the questions that came to my mind is this. I believe that there is a requirement in here that 25% of the units be deemed affordable. But I'm, at least in my limited search, I could not discern, and Tim, maybe you can help the board with this. I could not discern, how the 25% is to be, what the mix of the 25% affordable is going to be. Is it going to be, X number of 1 units, X number of 2 units, Y number of 3-bedroom units? How is the 25% going to be divvied up?
Is that not articulated in the application anywhere?
You know what, I couldn't find it, but I might not have been looking in the right place.
Yeah, let me take a spin. This may also be a good Judy question. Whether I mean, so there are regulations about, they obviously have to be, comparable and proportional to, the rest of the development, but there also has to be a certain number of family units. So my recollection is that is kind of, I actually know, strike that. I don't know what my recollection is. So we'll double check the application on that. And we'll check with Judy to see if that's typically kind of done, via the sort of post decision process with mass housing and DHCD.
Because there is it's laid out in A5. Okay, you can see it in the paragraph on this one where it is 2 of the 1s, 2 of the 2s, and 1 of the 3s. I just want to make sure that that's correct, because
It certainly prorates it.
Yeah.
That was going to be, that's sort of the obvious solution, but your point is well taken.
I just don't want to take it on face value.
I will check on that tomorrow and consult with Judy if she doesn't join us tonight.
A6 deals with parking, and I noted this particular paragraph as, I think the numbers are correct, but this is one of those ones where I think that this paragraph may need a deeper dive. I just want to make sure that, and attorney, there's a reference to a letter that the applicant's attorney provided to the board. This one is just one I think that needs another set of eyes and perhaps some editing on it. A7 is an example of just what are we calling plans? Because now in this paragraph, we have approved plans. So,
I'll take a careful look at that as part of my review, Frank. No problem.
This paragraph A8 begins to deals with the waiver list in Exhibit B, and it's basically requires the project to comply with everything that, unless it's been all the requirements unless specifically waived. Some of the requested waivers, and this is boilerplate language, may be granted conditionally by the board. We haven't gone through the list of waivers yet, so I'm not fully certain if some of the waivers are conditional or not, but that's something that we will nail down as we go through our review of the various waivers. And it also goes on, and again, there's a fair amount of language here, which is standard regarding the impact of such waivers and granted under the provisions of 40B. Basically, they only go so far. But this is one that at the appropriate time, we may need to revisit from a language perspective once we get our arms fully around the waiver list.
That seems right.
Nine. And 10 are basically notice provisions and set out who gets noticed on what, and in some cases when, and is my understanding that that language is pretty standard as well.
So the question I have there is, and I've had this on the other applications, just making sure that Tim, your team and the building inspector, et cetera, are all comfortable with that, because you've got to implement it,
Which one is this?
We're talking about 9 and 10, the notice provisions and how the consultants work and the payments of the fees and things like that, I mean, at this point, I'm sure you've got a process laid out, and one of our goals was to just make sure that process is consistent as applied. So to the extent we were even thinking about modifying this, you'd need to be comfortable with it. You also probably look at it, make sure that works for you. But I'm assuming that you've passed on this language before.
Yeah, I'll give this particular one a look. But if it's based on we've kind of honed this stuff over the course of half a dozen approvals.
Yeah.
So,
makes sense.
but I'll give it another double check just to make sure it's good.
Okay. 12 is also standard language, as I understand it. And Jim, this is just something for you guys to make sure that you continue to be comfortable with.
Yep.
A13, snow storage. I did not have a chance to review the plans. I looked very briefly, but I just want to confirm that there is a site designated on the approved plans for snow storage. It didn't ring a bell with me on that, in a very cursory review of the plans. Just something that needs to be double checked. And in A14, the only question I have there, the board in the language there, except to the extent inconsistent with applicable law, the board hereby designates the town's building inspector. I want to make sure that we're using the correct terminology, and is building inspector the correct terminology, or should it be the building commissioner or his or her designee? It's a very minor point, but I just want to make sure we're calling. We're designating the right person by the right designation.
I will check on that as well.
All right, affordability. Again, most of this stuff to my eye in my review was consistent with earlier decisions and doesn't vary from, and the requirements don't vary from decision to decision and are in many respects controlled by applicable statute and regulation. So I don't have any questions or comments on this.
A question here, I probably have had this question before, is in that first line, are they affordable in perpetuity or for the maximum period allowed by law? Or is the maximum period allowed by law perpetuity?
I can put that on my list.
I seem to recall you raising that question in an earlier case too.
Yeah, I think so.
So while we're on that paragraph, in that last sentence of it, is the applicant real, is this part of the regulations that the applicant is on the hook for making sure that that the affordable units are not only the tenants qualify, which I understand, but that the tenants are required to make them their domicile and primary residence?
I think so, yeah.
Yeah, okay. I mean, it makes sense, I guess. It's just wondering how the applicant accomplishes that. Maybe an affidavit.
B2, it requires that the regulatory agreement be recorded at the registry of deeds. Does it specify recorded by whom?
The applicant.
Yeah,
But now it's going to say that, right, Frank?
Huh?
Now it's going to say that.
Yeah, well. All right. B3 seems pretty straightforward. any questions or comments relative to paragraphs B4, B5, and B6?
No comments.
Nope, nothing yet. Not on the first draft. First read.
All right, C, submission requirements.
Is there a definition section in this? At some point where something that's capitalized, like personally identifying information is defined?
No. You just gotta find it where it first appears.
So what does that mean?
Capitalized terms are defined like when they first appear, you know?
No, I know that, but I mean, is it defined in this instrument?
Is what?
Is personally identifying information
Oh,
defined?
sorry. I didn't understand the
No, no,
question.
I'm not being
I
clear.
don't know.
Okay,
I believe that there is a definition of PII in the Commonwealth's data breach law.
okay,
Um,
maybe we want to reference that. I'm just trying to eliminate loopholes. I don't know. Let me look, I'll look at that.
okay. I believe it's defined in the data breach law.
Okay,
Okay. Submission requirements. So a lot of, if you will, meat and potato stuff in these next couple of pages. Who gets what, when, what type of information, related to a lot of the, notices and things like that. Tim, this strikes me as another one of those areas. I know it's consistent with earlier decisions. It's also, as I understand it, consistent with practice. It strikes me as one of those ones that as the town has gained more experience with developments, either of a 40B nature or of some magnitude, does this stuff still work? And are there any tweaks that would need to be made to make it easier for both the applicant and other stakeholders to comply appropriately with it?
So I'm actually in the middle of receiving submissions from the Ice House project. So I'll take another closer look at this section C and kind of be able to give a little bit of a real-time commentary on how it's working out. But we're doing okay so far. So if it's based on previous decisions, I think we're in mostly good shape. But I'll give it a specific review and flag anything that I think might be problematic.
Yeah, I mean, for example, 1D, proof that DigSafe has been notified at least 72 hours prior to the start of any site work. Looks good to me on paper, but I have no idea if that is doable in the real world. So, it's stuff like that, just like a reality check.
I'll give it a close look. I think we want to have those things in there rather than not. Just to keep, I don't want to say keep the applicant on their toes, but just as a flag that we want to make sure that they're doing the right thing. So, but I'll give that a specific check, and I'll speak with the building commissioner as well. He's kind of in the thick of it with me on the Ice House, so we'll be able to provide some feedback.
Okay. In 2, this is the notice regarding an intention to begin work. This is this is the one that led me to agree with the point relative to the role, like what continuing role Attorney Galvin may have in terms of being provided notice and so that he can in turn provide notice to his clients. And I do believe that the person in charge, or the person who's heading the Cushion Road Neighborhood Association, needs to be identified. I'm not particularly sure that Mr. Galvin was representing the Cushing Road Neighborhood Association, so I don't know if the second and third line of this particular paragraph is correct, but it was written in that way to raise the issue. I want to make sure that we have the right list of people who would need to receive this type of notice and whatever similar notices need to be made.
Frank, was there we literally just did it and it's already out of my mind. But you sound like you've reviewed that decision more recently than me. Did we identify a neighborhood group in the Amor Road decision? I know we identified council. I know we identified the abutters within 300 feet. But was there a named neighborhood group in that one?
I don't recall.
My concern with these things is, when you say abutters within 300 feet, that's very, we do that all the time. Counsel for abutters who, were participating in the hearing, we know who Mr. Galvin is. Once you start to get into, other things like that, I mean, we know, Ms. McIntosh spoke on behalf of the Cushing Road Neighborhood Association. I don't know if she's the president or just the spokesperson or whatever. These groups are, don't have the formality of, an abutters list. So I just want to make sure that when we identify groups or individuals that, it's in a capacity that we can get their contact information and have it, if and when construction takes place, which may not be for, a significant period of time, depending on how, appeals go. So if it's consistent with what we've done in previous approvals, that's fine. But I just want to make sure that we're putting into these decisions, actionable, requirements.
I share that. I share your concern, and it was actually Ms. McIntosh who did speak, I believe, regularly. I think it was Lori McIntosh, I believe, who spoke regularly on behalf of the Cushing Road Neighborhood Association. I was thinking of her specifically. If someone like that meets the other, I just want to make sure that the right people get the right notices at the right time. And I just think we need to make sure that we do that. I am looking at the Amor Road decision at the moment. In that particular decision, provide notice to the building inspector, planning director, and all abutters and abutters within 300 feet of those abutters and the Milton Southwest Neighborhood Association through their council. So you can see that this language mirrors.
Yeah, I think the issue with that is that, that is a group where sort of the Venn diagram of, abutters who participated in the hearing through council and that named association, the Venn diagram is a circle. Those are the people. If there's a question as to, so my concern here is, if Ms. McIntosh were to move next week, who do we send, something to? And maybe we put a pin in this and figure out the best way to have some sort of contact on file, with this approval. I'm sure there's a way to do it. We definitely want to make sure that people are informed. But we just want to be able to do it in a sustainable way that doesn't create problems with non-compliance later on.
Yeah, I mean, I'm, to borrow your verbiage, I'm putting a pin on in the language in this particular section. I just want, like I said, I just want to make sure the appropriate people get the appropriate notices in a timely fashion. And so that we can play with the language. I'm not wedded to this particular language. What I am wedded to is making sure that the notices are delivered when they need to be. So we're on the same page in the goal. We may have to wordsmith this particular paragraph a little bit, but there are at least 3 of us on the call who wordsmith for a living. So. All right. The rest of this stuff, paragraphs 3, 4, 5 is consistent with prior decisions, both in terms of the amount of money, the size of the bond, things like that. And there is some, there are the tree protection plan, stuff like that. It's all important stuff, but it's also stuff that is consistently made applicable to other decisions. So it bears review and looking at, but it's pretty consistent with not pretty consistent. It's exactly the same as what has been put in place in other decisions.
Is that, yeah, no, that's fine. I'm just reading 3 and is wondering that the applicant gave us a fairly, I don't want to say detailed, but a pretty extensive landscaping plan that may or may not comply with the literal language of minimizing destruction to existing trees. I mean, I think they tried to, but I just trying to figure out how to make that consistent with what they've already told us, the applicants already told us they're doing. We can revisit it. We don't need to waste time on it right now.
Okay. I noted paragraphs 6 and 7. The language, well, actually, 6, 7, and 8 all deal with pollution, drainage, stormwater, stuff like that. And this language is also consistent with what has been contained in prior plans. The question I have, and I have not had a chance to satisfy myself to that particular answer, is whether these sections, as they are currently drafted, work and are applicable to the current project. I'm not saying that they are. I'm not saying that they're not. What I'm saying is that I just haven't satisfied myself yet by looking at things and conversing whether they should remain in the decision or not. They are somewhat technical in nature, engineering related, and again, if we're going to require something, I want to make sure that we're requiring the right things for the right reasons. And I just don't know. Tim, do you have any opinion on the language contained in these particular paragraphs?
I'll have to give them a closer read. So if I can put that on my list, that'd be great.
Okay, thank you. Um, 9, submit a construction management plan. Is the language here sufficient? This is what has been in prior decisions. You know, the next several paragraphs, 10, 11, 12. The thing in 12 is we've got A to M. And to me, it looks just need to make sure that it is as comprehensive as it needs to be.
These are probably the kind of things, Frank, which is probably just need a careful read, you know, but they do all feel consistent to what we've required in other cases.
Yeah, they just need a double check. They just need another
Agreed.
set of eyes on them.
Yeah, I agree.
Because I mean, my eyes are glazing over now, so. The final plans and specifications are subject to review and approval by the board's designated agent. Who is the board's designated agent? Is that the board's?
The building inspector. We did that in another paragraph.
Okay.
You
thank
asked me to look at that. I have it on my list.
I must be getting to get whoopy here. Okay, all right. C2 and the paragraphs contained therein are also relatively standard. And I just want to point out paragraph C2(3), the requirement to obtain written confirmation from the DPW director that the necessary public water and sewer capacity is available for the project. I believe I recall that that was a question that was asked and raised during the course of the hearing, I believe by a member of the public. And I believe that Mr. Reardon noted that this particular requirement is in the decision, and that is how it is typically handled. So I just wanted to note that requirement for everything else is stuff that needs to be done almost from a paperwork and permitting process by the applicant prior to construction being able to begin. Again, the language in here is drawn directly from prior decisions, several prior decisions by the board. Paragraphs 9, again, payment of the additional fees. I also want to point out specifically paragraph 10, which deals with the continued oversight and review by the Milton Fire Department regarding fire safety related issues. This particular paragraph deals with fire safety equipment. Then signage, and the trash and recycling management plan for the Board of Health as well. After having reviewed these 12 or so paragraphs, I'm hard pressed to identify anything that has been missed. But again, this is also a set of things that needs another set of eyes to make sure that there isn't anything specific to this project that we haven't that we have missed. Okay. C3, again, things that need to be completed before the issuance of certificate of occupancy can be made. Paving, landscaping, fire safety issues, stormwater management, things like that. Maintenance of stormwater systems, things like that. Basically everything that needs to be done. Again, like several of the previous things, I want to make sure, again, another set of eyes, want to make sure that we've gotten everything here. And then again, C4, again, relative to the stuff that needs to be done prior to the issuance of the last, the certificate of occupancy for the last unit. Again, also consistent with prior decisions by the board. Any questions regarding any of the stuff in C?
No questions.
Yeah.
D1, D, project design and construction. So this is the stuff where some of the practical stuff, where the rubber meets the road, where there can be issues or whatnot that arise. In particular, I note D2, the trucking plan. And in this area, the trucking plan could be challenging, given the designation of Brush Hill Road as a scenic highway, as well as the concerns that were, and I'm mindful of the concerns that were expressed by the Cushing Road Neighborhood Association relative to their, well, their concerns about truck traffic on their street. And I know that Ms. McIntosh in particular had expressed a desire that there be no such traffic. Um, Having said that, a trucking plan will need to be developed, and this specifically requires it. Um, This may be an issue that requires additional attention by the board in terms of whether or not any specific requirements for such a trucking plan need to be included here. So, not suggesting it at this point, I'm raising it as an issue spotting for the board. Jeff, you look like you're about to say something.
Well, I was wondering with respect to this, to me, especially section D, it might be helpful to have Mr. Reardon take a look at this.
Works for me. Tim, again, going back to your point earlier this evening relative to folks who get notice, just pointing out the community contact section on this one.
Got it.
Um, The rest of this stuff is deals with some of the details associated with construction in itself, emergency access during construction site, storage of construction materials, how long stuff can remain in an unstabilized condition, when construction activity is allowed, and there are. Milton does have requirements in its bylaws relative to that, and those are not waived in terms of hours of operation and things like that. Also requirements dealing with mitigation of nuisances, if you will. By that, I mean vibration, dust, noise, that sort of stuff. In attempting to limit the inconvenience and disruption on the neighborhood relative to this sort of construction activity. Because it is disruptive. All construction is disruptive. So again, D11 deals with snow and ice removal, things like that. So all construction impacts, all stuff that will particularly interest the neighbors as the inconvenience relative to construction has its impact on the neighborhood, assuming construction's allowed. So E, the language in some of the paragraphs in E will probably need to be tweaked because this language again is drawn from earlier decisions and whatnot, and some of those decisions contemplated larger developments with larger driveways, roads, etc. I mean, this particular one has a driveway that leads to where the dumpster is located, to the entrance to the parking garage, and to the entrance of the outside parking facility. So some of the language here may not be completely appropriate for the size and design of this particular pathway. And that's something that we're going to have to take a look at. And one of the key questions I have is, and this was drawn specifically from another decision. I'm not quite sure that, and I need to have this question answered. I'm not quite sure whether or not the work required on Brush Hill Road will require a permit or approval from the Department of Conservation and Recreation. Jeff, it's a scenic highway, but do you have any idea if DCR gets involved? I don't.
I don't think they do.
Yeah, I mean, so again, this is one of those ones I think it's in the initial draft, it's kind of laid out by throwing everything in there, but I'm not quite sure that everything in here is completely, totally appropriate.
I'll take a close look.
You know, and you can see that in E, in the next one, F1, where you can see where the genesis of that particular language was borrowed from, so. Busted.
Yeah.
So,
It's probably coming from the ice house, right?
Well, Amore Road is mentioned in
Amore Road.
F1, but.
Oh, well, yeah, okay, well, that makes sense. Amore Road, that makes sense. The Truman Highway down there.
the other thing, the Amore Road made sense because just from a size perspective too.
Okay.
If you looked at all the decisions just from the unit size perspective, it seemed to be the one that, in terms of not reinvent, I'm a big one for not reinventing the wheel. So,
Yeah,
but modifying the wheel as is necessary. In G, the water, sewer, and stormwater and other utilities. Jeff, you made an earlier suggestion that perhaps Mr. Reardon would be appropriate to look at something earlier. It could also be appropriate to have him look at this particular one as well.
Yeah, I agree.
so
Because not only here do we have the stormwater and other things, but here, Nick, I think you were the one, if I recall correctly, and correct me if I'm wrong, who noted some of the lighting plan issues.
there were, yeah, I recall that the abutters had concerns about both about the external lighting complying with dark sky requirements. They requested a lighting plan. And they were also concerned about the shining of headlights from the garage exit, I believe, into the property abutting to the north especially. And that there was, I think, if my recollection is correct, there was going to be consultations between the developer and the neighbor to come up with a suitable solution to that, but maybe I'm remembering it incorrectly.
Well, this is the first mention of lighting in the decision. I know that that's probably an issue that's probably most appropriately handled in the conditions part of the decision, but I just want to mention it here because of that.
All right, I'll look at it.
H is also, security for the completion of the infrastructure. There are a number of general conditions here. Again, the general conditions bear review. The general conditions here are conditions that have been generally made applicable to other projects within the town. Query whether there are any specific, mix my metaphors, specific general conditions that would need to be made applicable to this. I'm thinking of anything additional needs to be said about, for example, school bus stop or other matters.
I think the school bus stop is an excellent thing to include as part of the conditions. And I also noted that,
Been there before, no?
well, no, I think it's on the plan, unless I could be also mixing up my cases too.
It's in there earlier decision. It's in the earlier part of it. I saw it.
Okay. No, I was just gonna mention,
agree, though.
I know Mr. Reardon, his last letter that came in had half a dozen of proposed conditions that he thought should be in there into our final decision. And I certainly want to make sure that, I'll be happy to take a look to make sure that what Sean has recommended is actually in the decision.
Okay. What's the board's pleasure? We're now at the 2-hour mark. We've done a lot of issue spotting. We've done a lot of looking at things. Ms. Barrett has been unable to join us. So what's the board's pleasure in terms of continuing or calling it a night for tonight and scheduling another gathering by this board for next week, mindful of the 40-day deadline. What's the board's pleasure?
I'd vote for having another meeting and getting to you, Frank, and to Judy comments on this draft, and we can take a look at a subsequent draft. I think that's my sense, what we ought to do.
That's absolutely my sense. This came in this morning. I really didn't have enough of a chance to go through it in the level of detail that I think we all need. So I would love that opportunity. And I think a meeting in the middle of next week at some time convenient would be a good time to go to get back again.
Okay. So I'm going to stop sharing my screen.
Okay.
Now. There we go. So unfortunately, I think the time pressure is such that the board would need to meet next week.
Yeah, that's fine.
And fortunately, for me, from a personal point of view, I am available any night next week. I guess, Miss Rich, subject to the availability of the town's facilities to accomplish a meeting.
Next Tuesday or Wednesday. What works for you guys?
Either of those days would be fine for me. I'm available both. The 25th.
Wednesday, Tuesday I can't do. Wednesday I could do.
All right.
Okay.
So why don't we continue this exercise in the meantime, working on issues so that we will continue this exercise on Wednesday, the 26th at 7 p.m.
That's
Okay.
fine.
Very
Okay.
good.
All right. Any other Crystal, that work for you?
Yes, it does.
Tim, does that work for you?
It does, yes.
Okay, thank you. Anything else that any members of the board want to mention before we sign off? I think that there has to be some review and some additional drafts, and I will also coordinate with Mr. Sawinski in terms of reaching out to Ms. Barrett.
Very good.
Nothing else.
All right. Thanks, everybody. Appreciate your eagle eyes this evening and
Thank
your
you.
continuing efforts.
Good night.
Right.
Thank you.
Thank
Thanks,
you,
everybody.
guys.
Good night.
Have a good evening.